Companies Act, Section 468, Powers of the Central Government to make rules relating to winding up of companies. Section 468 of the Companies Act, 2013 grants extensive rulemaking powers to the central government in matters relating to the winding up of companies. These rules are intended to ensure smooth functioning, consistency in legal processes, and clear procedural guidance in winding up cases that are brought before the tribunal. This provision emphasizes that such rules should align with the Code of Civil Procedure, 1908, while also allowing flexibility to cover procedural and administrative matters specifically connected to winding up proceedings. 1. Rulemaking Authority. Frame rules that are consistent with the Code of Civil Procedure, 1908. Provide procedures and requirements for all aspects of winding up, particularly where the Act specifies that something is to be prescribed. This authority ensures that any procedural gaps in the Act can be effectively addressed through delegated legislation. 2. Specific matters for rulemaking. Section 468, 2, clarifies that the central government's power covers a wide range of procedural aspects, including but not limited to the following. A. Modes and conduct of winding up proceedings before the tribunal. B. Holding meetings of creditors and members in connection with schemes under Section 230, compromises, arrangements, and reconstructions. C. Implementation of reduction of share capital, where applicable. D. All applications required to be submitted to the tribunal under this Act. E. Procedure to determine wishes of creditors and contributors, including convening and conducting meetings. F. Preparation and settlement of the list of contributors and rectification of the register of members when required. G. Collection and distribution of company assets, including taking possession of money, property, books, and records on behalf of the liquidator. H. Issuing calls on contributors to meet liabilities. I. Fixing deadlines within which claims and debts must be proved before liquidation proceeds further. These provisions help streamline the liquidation process and safeguard the rights of stakeholders. 3. Continuation of earlier rules until replaced. Any rules previously made by the Supreme Court under the earlier Companies Act, 1956, relating to winding up shall continue to remain in force even after the commencement of the 2013 Act. These older rules will remain valid until the central government notifies new rules under this section. Any reference to the High Court in earlier rules will now be construed as a reference to the National Company Law Tribunal, NCLT. This ensures continuity and avoids procedural confusion during the transition to the new Act. Purpose and importance of Section 468. Providing procedural clarity in winding up matters. Ensuring fair and efficient liquidation processes. Protecting creditors' and contributors' interests. Enabling centralized and uniform regulatory oversight. Reducing delays and legal uncertainties by empowering government to prescribe details through rules. For more details, contact us.